This presentation to the Association of Injured Patients will focus on incidents where a patient experiences significant harm from treatment they would have refused if informed of that specific risk. The AIP is a non-for-profit organization that advocates for patients injured as a direct result of medical negligence. Current statistics highlight the significance of this issue. Medical negligence results in approximately 18,000 deaths and 50,000 disabilities in Australia annually. Beyond the devastating physical and emotional toll on patients and those close to them, the financial burden is also severe. Such incidents cost the health sector $4.1 billion between 2017 and 2018 alone. Additionally, roughly 1 in 10 patients is harmed by adverse events, 50% of which are preventable. Between 2012 and 2013, of the 1,500 claims that were made, a mere 2.5% went to court. A figure so low reflects the insufficiencies in the current system, including a lack of deterrence, high litigation costs, and a severe emotional toll. This presentation will highlight the reforms needed in the current legislation in Queensland governing failure to warn cases. In particular, it will address the significant contention surrounding the application of causation, as well as the insufficiencies of lump sum damages. Lastly, it will suggest the New Zealand no-fault scheme as an alternative approach to the current system. The relationship between doctors and patients is an established duty in Queensland. This duty of care encompasses all aspects of practice, including examination, diagnosis, treatment, and the provisions of information. Siddaway and Bethlehem, Rogers and Whitaker. In failure to warn cases, the existence of that doctor's duty of care is unambiguous and imposes no unfair burden on either party. Accordingly, it does not give rise to any need for reform, MSP and SP. Breach occurs where a person fails to take precautions against the risk of harm that was foreseeable, not insignificant, and where a reasonable person in the position of the defendant would have taken such precautions. In determining whether a reasonable person would have taken precautions, the court considers the probability and seriousness of the harm, as well as the burden of taking precautions and the social utility of the activity that created a risk of harm. The Shirt test of foreseeability from Wyong Shire Council reiterates what is outlined in Section 9, subsection 1 and 2 of the Civil Liability Act, while also considering the foreseeability of the harm, finding that a foreseeable risk is one which is not far-fetched or fanciful. In failure to warn cases, this test frames the doctor's obligation to disclose any material risks, since a risk that is not far-fetched or fanciful is one a reasonable patient would expect to be warned about. Although this threshold was more impartial, the IP report criticized it for being over-inclusive. Instead, it suggested that a foreseeable risk is one which is not insignificant, imposing an unjustly higher threshold for an injured patient to prove foreseeability. The reasonable person test outlines that there are relevant characteristics to the finding of a reasonable person. In the case of failure to warn, this includes determining the standard of care, reasonable care and skill required is that of the ordinary skilled person exercising and professing to have that special skill. An additional characteristic to evidence reasonableness is possibly custom, practice, and regulation. However, this is not determinative and a weak defense, as the practice in itself may be unreasonable. Trentways. The opposition of the custom characteristic in various cases prevents the risk of entrenching unreasonable practices that favor doctors. The foundation for breach and failure to warn cases is the material risk test, which asks if in the circumstances a reasonable person in the patient's position would regard it as significant, or if the doctor knew or ought to have known that this patient would. This test has been codified by the CLA in the following two principles. Firstly, a doctor does not have a proactive duty to provide information unless it can be established that a reasonable person in the circumstances would require such information to make a reasonably informed decision. Secondly, there is a reactive duty to provide information the doctor knows or ought reasonably to have known the particular patient wants to be given before making the decision. This is an approach that balances objective and subjective elements that ensure the patient's autonomy and the judgment of the doctor are considered. Further, there is an established established standard of care for professionals. However, failure to warn is excluded from the scope of this application. This exclusion is just, as the standard reflects principles from the English Bolam test, which outlines that a doctor is not negligent if they act in accordance with a practice accepted at the time as proper by a responsible body of medical opinion, even though other doctors adopt a different practice. Bolam and Frian Hospital Management Committee. The application of this test in failure to warn cases in Australia was refuted by the High Court in Rogers and Whittaker, a decision that was affirmed by Nakasis and Western General Hospital. Causation is a two-limb approach. The first limb, factual causation, outlines that a plaintiff bringing a failure to warn claim is required to establish that, had they been warned of the relevant risk before consenting to treatment, they would not have undergone said treatment. This section is in essence the common law but-for test. This test has long been criticized for its inadequacy in serving those injured by risks that they were not warned of, with many cases dictating that causation is all ultimately a matter of common sense. And in truth, the conception of causation is not susceptible of reduction to a satisfactory formula. It is also a test that is subject to hindsight bias. The second limb, scope of liability, is a normative question. Whether the failure to disclose the risk makes the doctor legally responsible for the injury that materialized. This assessment is facilitated by directing courts to consider, inter alia, whether and why the defendant should be responsible for the harm. The defendant, in this case a doctor, would aim to narrow the scope of liability through either remoteness or novus actus intervenus. To prove remoteness, a doctor would argue that the injury that materialized was not reasonably foreseeable. A rule that applies to this test is the eggshell skull rule, which posits that the tortfeasor must take the patient as they are. A novus actus intervenus would also limit this scope by breaking the chain of causation. This can occur through a human action regarded as either voluntary or causally independent. Recommendation 29 of the IP report suggested that to bridge the evidentiary gaps that arise from the common law but-for test, causation can be established where a failure to warn materially contributed to the harm, even if factual causation has not been proven. Determining whether cases are appropriate for this exception is a normative question, requiring courts to weigh factors such as whether responsibility should be imposed on the defendant or whether the loss should lie where it fell. To resolve the counterfactual question of what the plaintiff would have done, courts should apply a subjective assessment based on circumstances while excluding the plaintiff's testimony of what they would have done. These recommendations have been incorporated into the legislation through Section 11, subsections 2, 3, 3A, and 3B of the CLA. Section 11, subsection 2 permits a finding of causation in exceptional cases where negligence materially contributes to harm or risk, even if factual causation cannot be strictly proven. This subsection is designed to address two situations where such a determination can be made. Firstly, where there are cumulative causes materially causing harm, or, secondly, where negligent conduct materially increased the risk of harm. However, the ambit of this provision is unclear. This creates uncertainty as the scope of those principles is contested, leaving injured patients vulnerable to inconsistent judicial interpretation. The test in the CLA, Section 11, subsection 3, requires courts to assess subjectively what the plaintiff would have done if warned of the risk that materialized. This is assessed while simultaneously excluding their testimony unless it is against their interest. Even though this eliminates the possibility of hindsight bias, it silences the plaintiff's account, entrenching an evidentiary imbalance that favors doctors. Overall, causation remains an ambiguous and contentious element, heavily shaped by judicial interpretation. This creates uncertainty and often disadvantages injured patients, as courts frequently impose restrictive thresholds. A failure to warn claim will be defeated if the risk that materialized was an obvious risk. An obvious risk is one that would have been obvious to a reasonable person in the position of the injured patient. This includes a risk that are a matter of common knowledge and can be capable of being low probability, not prominent, conspicuous, or physically observable. Additionally, there is no proactive duty of a doctor to warn of an obvious risk unless the patient requested information or advice about that risk, or a reasonable person would require such information to make an informed decision about the procedure. Lastly, contributory negligence may see a reduction in damages up to 100%. This is assessed on the basis of what a reasonable person in the plaintiff's position knew or ought reasonably to have known at the time. A patient who has met all the elements of negligence and has taken reasonable steps to mitigate their loss will be eligible for compensation for their injury through damages. They can be either nominal, aggravated or exemplary, or compensatory, special damages and or general. Damages are assessed as a lump sum, once and for all. In many cases, lump sum compensation falls short of adequately providing for future, usually lifelong care and lost income. It is wrong to assume that the plaintiff will wisely invest the lump sum award to produce income for the period of incapacity assessed by the court, and there is often inadequate allowance made for the effects of inflation. With economic inflation growing at its fastest pace in 20 years, in the past 20 years, this is a more pressing issue than ever and reinforces the need for reform. The tort system, for failure to warn as it is ill-equipped to meet the needs of injured patients. Explicitly, the application of causation remains contentious to the detriment of injured patients. Further, reliance on lump sum damages risks undercompensating those with ongoing medical and financial needs as a result of failure to warn scenarios. Hence, it is clear that the existing tort system for medical negligence is a poor mechanism for meeting injured patients' needs for information, distributed justice, and reconciliation. The current response to medical error is grossly insufficient, harmful, and further contributes to patient harm and loss of trust. These experiences are heightened in marginalized ethnic communities, as they face higher financial barriers when seeking justice, are often given less damages than non-marginalized communities, and are also subject to systemic biases that are entrenched in the tort system. These issues would be eradicated through a no-fault scheme. New Zealand is the greatest exponent of a no-fault scheme through the Accident Compensation Corporation. This replaced the tort system in 1972 after the report of the Woodhouse Commission. This system better reflects distributive justice and reconciliatory aims by reducing litigation harm, rebuilding trust, and ensuring timely redress. This scheme covers the cost of personal injuries, including medical and rehabilitation costs, weekly expense compensation of up to 80% of lost earnings, one-off payments for permanent injuries, as well as funeral costs. Patients who have been injured as a result of the non-disclosure of the risk that materialized are currently being further harmed emotionally and in terms of justice by the current medical negligence litigation system. Concerning the elements of negligence, contentious application of causation and limited lump sum compensation mechanisms risks undermining fairness for patients. This highlights the need to reform towards a more balanced and accessible no-fault scheme, such as the one seen in New Zealand.